Hello and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer and I'm a Senior Faculty Specialist and Extension Specialist here in the Department of Ag and Resource Economics. And with today's episode, we're going to talk about a lawsuit that happened or was filed late in 2020 involving USDA and some loan guarantees offered for two poultry farms. So, as I just said, in late 2022, a citizens group brought a lawsuit against the U.S. Department of Agriculture, Farm Service Agency, Farm Credit, Mid-America, and two poultry growers, Dan and Trang, for claims that the loan guarantees that USDA gave on two farm credit loans to the two growers violated federal law. The citizen group argues that the loan guarantees violated the federal law enabling FSA to grant loan guarantees, and that FSA failed to do an adequate environmental review to comply with federal law. This action is in concerned citizens of West Tennessee versus USDA. For a little bit of background on it, a citizens group is bringing a lawsuit against USDA challenging the environmental review and authorization of a loan guarantee to two poultry operations contracting with Tyson Foods. The operation received loans from Farm Credit Mid-America. Mid-America worked with the borrowers to receive FSA loan guarantees for 90% of both operations. So both operations received two separate loan guarantees. The loan guarantees were provided under the Farm Ownership Program. The citizen group argues in the complaint about three issues. First, FSA failed to comply with the legislation creating the Loan Guarantee Program that limits eligible applicants to owner-operators of not larger than a family farm. The second issue is that FSA loaned more than the maximum allowed under the program. And then the third issue is that FSA failed to comply with the National Environmental Policy Act, or NEPA, when approving the loan guarantees. So we'll take each one of these as we look at it. So focusing on the first issue raised by the citizens group is an interesting argument. The group argues that the integrator, in this case Tyson Foods, will control the day-to-day operation of the poultry farm. Looking at the statute, federal law requires that the borrower be or will become owner-operators of not larger than family farms. That's in Section 1922A1. The regulations broadly define what a family farm to be. They can produce agricultural commodities for sale in sufficient quantities so that it is recognized as a farm rather than a rural residence, has both physical labor and management provided as follows. The majority of day-to-day operational decisions and strategic management decisions are made by either the borrower with input and assistance allowed from persons who are either related to the borrower by blood or marriage, or a relative for an individual borrower, or the members responsible for operating the farm in the case of an entity. A substantial amount of labor to the operation is provided in the following means. The borrower with input and assistance allowed from members who are either related to the borrower by blood or marriage, or a relative for an individual borrower, or members responsible for operating the farm in the case of the entity. The farm may use full-time labor in amounts only to supplement family labor, may use reasonable amounts of temporary labor for peak workload periods, or intermittently for labor-intensive activities, and that's in 7 CFR Section 761.2. The group contends that Tyson owns the chicken and the feed and controls how the houses are built, so that Tyson and not the two operators basically control the operation. Therefore, the farm does not meet the statutory definition requirements to qualify for the loan guarantees because of Tyson's control. The interesting thing about this is when you look at the list of people that were sued in the initial complaint, Tyson is not one of them. It's the two borrowers, Farm Service Agency, USDA, multiple officials throughout those agencies, and then the two borrowers and Farm Credit. The next argument focuses on the requirement that the borrowers be unable to obtain sufficient credit elsewhere to finance their actual needs at reasonable rates and terms, taking into consideration prevailing in private cooperative rates and terms in communities in or near the applicant resides for loans for similar purposes and periods of time. That's in section, again, 1922A1. The group argues that the two borrowers received credit through Farm Credit of Mid-America without the FSA loan guarantees. Because the two borrowers could receive credit, FSA should not have guaranteed the loan. This argument fails to consider that Farm Credit may not have loaned the money without the loan guarantees. The borrowers are new poultry growers who may only have been considered for loans with FSA granting the loan guarantees. The final argument is related to the fact that the two borrowers applied for a loan guarantee, or the final loan guarantee related argument is that they applied for a loan guarantee amount that is above what they could receive. They each received $1,776,000, or a total of $3,552,000. The citizen group argues that the two poultry operations should be viewed as one operation and only entitled to the one maximum amount, the $1.76 million. Therefore, FSA violated the program rules by granting more. The issue with this argument is that each bought their farmland. There's basically a public road dividing the properties in half, and upon purchasing the property, each transferred their property into their own LLC. It appears from just looking at the facts, we are not dealing with one borrower, but two borrowers applying for separate loans and loan guarantees on separate farmland. The final argument is that FSA violated NEPA by failing to do a proper environmental review of the two proposed poultry farms before granting the loan guarantees. The citizen groups argues that FSA was unable to provide public notice to consider and disclose direct effects, to consider and disclose indirect and cumulative effects, to consider reasonable alternatives to evaluate or disclose mitigation measures, and failed to prepare an environmental impact statement that may have been required under NEPA. The NEPA claims are where the complaint becomes confusing, because the loan guarantee application dates need to be given. I've talked about this before, and I'll provide it in the show notes. It's in the blog post as well. In September 2012, the Trump administration issued a final rule regarding NEPA revisions went into effect. These changes included exemptions from NEPA review for loan guarantees, including FSAs. Based on some of the dates in the complaint, it appears the loan guarantee is potentially exempt from NEPA review, and these arguments could be moot, but we're not sure. We'll have to wait and see how FSA, the lender, and the borrowers respond to this, to these arguments. The other interesting issue is whether the citizen group actually has standing to bring the NEPA challenge. This is considering because of a similar lawsuit in Maryland involving an environmental group. In that case, the Court of Appeals found the group did not have standing. That could also be an issue here. It will be interesting to see how the parties respond to all this and what can happen in the future. I'll be watching it just as it moves through, so we kind of get some ideas as to where this is going. But thank you for listening. If you have any questions, please email me at lgoering@umd.edu, or you can tweet me or find me on Instagram at aglawpaul. And also, if you haven't yet, check out MSBA's Legal Lab, which is a collection of podcasts. I'm a part of it. Other podcast members of the Maryland State Bar are on there as well, so you might find something else you're interested in as well. Thank you again for listening, and enjoy the rest of your day.